A few minutes of Hart is better than none at all. So this is about 15 minutes of HLA Hart. I'll be reading from The Concept of Law, which is an absolute masterpiece, one of the best books ever written. This is from chapter 6, The Foundations of a Legal System. The heading, Rule of Recognition and Legal Validity. According to the theory criticized in chapter 4, the foundations of a legal system consist of the situation in which the majority of a social group habitually obey the orders backed by threats of the sovereign person or persons who themselves habitually obey no one. This situation is, for this theory, both a necessary and a sufficient condition of the existence of law. We have already exhibited in some detail the incapacity of this theory to account for some of the salient features of a modern municipal legal system. Yet nonetheless, as its hold over the minds of many a thinker suggests, it does contain, though in a blurred and misleading form, certain truths about certain important aspects of law. These truths can, however, only be clearly presented, and their importance rightly assessed, in terms of the more complex social situation where a secondary rule of recognition is accepted and used for the identification of primary rules of obligation. It is this situation which deserves, if anything does, to be called the foundations of a legal system. In this chapter, we shall discuss various elements of this situation which have received only partial or misleading expression in the theory of sovereignty and elsewhere. Wherever such a rule of recognition is accepted, both private persons and officials are provided with authoritative criteria for identifying primary rules of obligation. The criteria so provided may, as we have seen, take any one or more of a variety of forms. These include reference to an authoritative text, to legislative enactment, to customary practice, to general declarations of specified persons, or to past judicial decisions in particular cases. In a very simple system like the world of Rex 1, depicted in chapter 4, where only what he enacts is law, and no legal limitations upon his legislative power are imposed by customary rule or constitutional document, the sole criterion for identifying the law will be a simple reference to the fact of enactment by Rex 1. The existence of this simple form of rule of recognition will be manifest in the general practice on the part of officials or private persons of identifying the rules by this criterion. In a modern legal system where there are a variety of sources of law, the rule of recognition is correspondingly more complex. The criteria for identifying the law are multiple and commonly include a written constitution, enactment by a legislature, and judicial precedents. In most cases, provision is made for possible conflict by ranking these criteria in an order of relative subordination and primacy. It is in this way that in our system, common law is subordinate to statute. It is important to distinguish this relative subordination of one criterion to another from derivation, since some spurious support for the view that all law is essentially, or really, even if only tacitly, the product of legislation has been gained from confusion of these two ideas. In our own system, custom and precedent are subordinate to legislation, since customary and common law rules may be derived of their statutes as law by statute. Yet they owe their status of law, precarious as this may be, not to a tacit exercise of legislative power, but to the acceptance of a rule of recognition which accords them this independent, though subordinate, place. Again, as in the simple case, the existence of such a complex rule of recognition with this hierarchical ordering of distinct criteria is manifested in the general practice of identifying the rules by such criteria. In the day-to-day life of a legal system, its rule of recognition is very seldom formulated, is very seldom expressly formulated as a rule, though occasionally courts in England may announce in general terms the relative place of one criterion of law in relation to another is when they assert the supremacy of acts of parliament over other sources or suggested sources of law. For the most part, the rule of recognition is not stated, but its existence is shown in the way in which particular rules are identified either by courts or other officials, or private persons or their advisors. There is, of course, a difference in the use made by courts of the criteria provided by the rule and the use of them by others. For when courts reach a particular conclusion on the footing that a particular rule has been correctly identified as law, what they say has a special authoritative status conferred on it by other rules. In this respect, as in many others, the rule of recognition of a legal system is like the scoring rule of a game. In the course of the game, the general rule defining the activities which constitute scoring, that's runs, goals, and so on, is seldom formulated. Instead, it is used by officials and players in identifying the particular phases which count towards winning. Here, too, the declarations of officials, umpire or scorer, have a special authoritative status attributed to them by other rules. Further, in both cases, there is the possibility of a conflict between these authoritative applications of the rule and the general understanding of what the rule plainly requires according to its terms. This, as we shall see later, is a complication which must be catered for in any account of what it is for a system of rules of this sort to exist. The use of unstated rules of recognition by courts and others in identifying particular rules of the system is characteristic of the internal point of view. Those who use them in this way thereby manifest their own acceptance of them as guiding rules, and with this attitude, there goes a characteristic vocabulary different from the natural expressions of the external point of view. Perhaps the simplest of these is the expression, "It is the law that," which we may find on the lips not only of judges, but of ordinary men living under the legal system when they identify a given rule of the system. This, like the expression out or go, is the language of one assessing a situation by reference to rules which he, in common with others, acknowledges as appropriate for this purpose. This attitude of shared acceptance of rules is to be contrasted with that of an observer who records ab extra the fact that a social group accepts such rules but does not himself accept them. The natural expression of this external point of view is not, "It is the law that," but in England, they recognize the law as whatever the Queen in Parliament enacts. The first of these forms of expression we call an internal statement because it manifests the internal point of view and is naturally used by one who, accepting the rule of recognition without stating the fact that it is accepted, applies the rule in recognizing some particular rule of the system as valid. The second form of expression we shall call an external statement because it is the natural language of an external observer who, of the system who, without himself accepting it as its rule of recognition, states the fact that others accept it. If this use of an accepted rule of recognition in making internal statements is understood and carefully distinguished from an external statement of fact that the rule is accepted, many obscurities concerning the notion of legal validity disappear. For the word valid is most frequently, though not always, used in just such internal statements applying to a particular rule of a legal system, as stated, the accepted rule of recognition. To say that a given rule is valid is to recognize it as passing all the tests provided by the rule of recognition, and so as a rule of the system. We can indeed simply say that the statement that a particular rule is valid means that it satisfies all the criteria provided by the rule of recognition. This is incorrect only to the extent that it might obscure the internal character of such statements, for, like cricketers, out, these statements of validity normally apply to a particular case of a rule of recognition accepted by the speaker and others, rather than expressly state that the rule is satisfied. Some of the puzzles connected with the idea of legal validity are said to concern the relation between the validity and efficacy of law. If by efficacy is meant that the fact that a rule of recognition which requires certain behavior is obeyed more often than not, it is plain that there is no necessary connection between the validity of any particular rule and its efficacy, unless the rule of recognition of a system includes among its criteria, as some do, the provision, sometimes referred to as a rule of obsolescence, that no rule is to account. Okay. The no rule is to count as a rule of a system if it has long ceased to be efficacious. From the inefficacy of a particular rule, which may or may not count against its validity, may distinguish a general disregard of the rules of the system. This may be so complete in character and so protracted that we should say, in the case of a new system, that it had never established itself as a legal system of a given group, or in the case of a once established system, it had ceased to be the legal system of the group. In either case, the normal context or background for making any internal statements in terms of the rules of the system is absent. In such cases, it would be generally pointless either to assess the rights and duties of particular persons by reference to the primary rules of a system, or to assess the validity of any of its rules by reference to its rules of recognition. To insist on applying a system of rules which had either never actually been effective or had been discarded would, except in special circumstances mentioned below, be as futile as to assess the progress of a game by reference to a scoring rule which had never been accepted or had been discarded. One who makes an internal statement concerning the validity of a particular rule of a system may be said to presuppose the truth of the external statement of fact that the system is generally efficacious. For the normal use of internal statements, for the normal use of internal statements is in such a context of general efficacy. It would, however, be wrong to say that statements of validity mean that the system is generally efficacious. For though it is normally pointless or idle to talk of the validity of a rule of a system which has never established itself or has been discarded, nonetheless, it is not meaningless, nor is it always pointless. One vivid way of teaching Roman law is to speak as if the system were efficacious still, and to discuss the validity of particular rules and solve problems in their terms. And one way of nursing hopes for the restoration of an old social order destroyed by revolution and rejecting the new is to cling to the criteria of legal validity of the old regime. This is implicitly done by the white Russian who still claims property under some rule of descent, which was a valid rule under Tsarist Russia. A grasp of the normal contextual connection between the internal statement that a given rule of a system is valid and the external statement of a fact that the system is generally efficacious will help us see in its proper perspective the common theory that to assert the validity of a rule is to predict that it will be enforced by courts or some other official action taken. In many ways, this theory is similar to the predictive analysis of obligation which we considered and rejected in the last chapter. In both cases alike, the motive for advancing this predictive theory is in the conviction that only thus can metaphysical interpretations be avoided. That either a statement that a rule is valid must ascribe some mysterious property which cannot be detected by empirical means, or it must be a prediction of future behavior of officials. In both cases, also the plausibility of the theory is due to the same important fact, that the truth of the external statement of fact, which an observer might record, That the system is generally efficacious and likely to continue so is normally presupposed by anyone who accepts the rules and makes an internal statement or obligation of validity. There are two, the two are certainly very closely associated. Finally, in both cases alike, the mistake of the theory is the same. It consists in neglecting the special character of the internal statement and treating it as an external statement about official action. This mistake becomes immediately apparent when we consider how the judge's own statement that a particular rule is valid functions in judicial decision. For, though here too, in making such a statement, the judge presupposes but does not state the general efficacy of the system, he plainly is not concerned to predict his own brother's official action. His statement that a rule is valid is an internal statement recognizing that the rule satisfies the tests for identifying what is to count as law in his court and constitutes not a prophecy of but part a prophecy of but part of the reason for his decision. There is indeed a more plausible case for saying that a statement that a rule is valid is prediction, and such a statement is made by a private person. For in the case of conflict between unofficial statements of validity or invalidity and that of a court in deciding a case, there is good cause sense in saying that the former must then be withdrawn. Yet even here, as we shall see when we come in chapter 7 to investigate the significance of such conflicts between official declarations and the plain requirements of the rules, it may be dogmatic to assume that it is withdrawn as a statement now shown to be wrong because it has falsely predicted what a court would say. There are more reasons for withdrawing statements than the fact that they are wrong, and also more ways of being wrong than this allows. The rule of recognition, providing the criteria by which the validity of other rules of a system is assessed, is in an important sense, which we shall try to clarify, an ultimate rule, and where, as is usual, there are several criteria ranked in order of relative subordination and primacy. One of them is supreme. These ideas of ultimacy of the rule of recognition and the supremacy of one of its criteria merit some attention. It is important to disentangle them from the theory which we have rejected that somewhere in every legal system, even though it lacks behind legal forms, there must be a sovereign legislative power which is legally unlimited. Alain, merci.